Welcome to Channel AMEC, your insight to the Australian visa system. Good day everyone, my name is Carl Young, your online YouTube visa consultant. Are you interested about migrate to Australia? Why don't you consider to subscribe to my channel and turn on the bell on the side so once we have all the updates and news, be the first one getting all the insight. Now today's video, we will follow up on the previous video in regards to the category of employment sponsored visa, as it has become one of the highly sought category visa, whereby the 25th of November 2023, about a month or half ago, back in late 2023, announcements of the relaxation and expansion of employment sponsored visa. It has become a highly sought interest visa category. Now today we are gonna talk about a little bit more in detail how an overseas business could actually utilize this visa category to expand further into Australia and perhaps nominate, I'm not too sure, probably the business owner or the highly senior executive or managers to be there working in Australia. And we also talk about how it could potentially or not potentially pathway to permanent residency, but we'll have a look at it later of this video. So now first thing, let's go to the standard business sponsor, which I have detailed explained it in my last video, but that's more for the Australian employer. So today we'll focus on this part where it have legally established current operating business, whereby it says the Australian business can be in your business can be in or outside Australia. However, the immigration's webpage does not provide much of detail in regards to how an outside and overseas business could actually sponsor. So let's jump into the actual law and stuff where there's a lot of policies and wordings in here, but I will take a look. I'll take an explanation to you in every single detail here. So as you may notice, this is the most updated policy, whereby the top left corner it's stated on the 1st January 2024. So very updated stuff, where under the policy 3.5.2.2 assessment of lawfulness of overseas business. So let me have a little read and I'll explain further. So basically, it says overseas businesses need to demonstrate satisfaction of decision maker that they're legally established under the relevant law of the country. Well, it's pretty easy as long as you have a business in whichever the country that is. You have the business registry and the financial documents. You'll meet that requirement there. This means that if there's a business registration system under the law of the home country, it's expected the applicant to have registered accordingly. Okay, so that's pretty simple to understand. And note here it says if an overseas business registered in Australia, assessment of lawful, there will be an ABN is in fact operating business in Australia. So if it's already registered in Australia, generally it's already with the registered name and it will become an Australian business. That's what they're trying to say. It will be appropriate for Australian registered entity of that overseas business to be SBS anyway. Now, second point, it says if the overseas business is registered in Australia, there's no other evidence that they are actually operating in Australia. That is, the supposed document points out business operating under exclusive outside Australia is appropriate for overseas business to be the SBS approval. So what does that actually mean? That has two scenarios here. Let me explain. It means that the overseas business has registered business in Australia, whereby the overseas entity probably take partially or wholly shares of that Australian entity, so that will still count as an overseas business, or perhaps it's entering into a partnership with another Australian entity to conduct some sort of innovation or research, whatever the project that's gonna be. And secondly, it's talking about a company actually registered Australian entity, but it hasn't really operated in Australia yet. It's looking towards expanding it. So basically, it has no taxation status or records, so we will still count it as an overseas business. So in both scenarios, it will have the Australian entity. It's not required to have an Australian entity, by the way. The Australian entity have major share held by an overseas entity. So that's basically what it's trying to say. It's going to be a little bit complicated, but it's how it will be formed anyway. Okay, let's move down to 3.5.5 where it says operating business outside Australia. So the paragraph 2.59H, which is going to be the paragraph within the migration regulation, applies to standard business sponsor applicant lawfully operating business outside Australia and do not lawfully operate business in Australia. It says decision maker may consider criteria made if the applicant provide evidence of demonstrating the purpose of seeking approval of SBS, enabling sponsoring TSS visa holder who is assist to establish in establishing on the applicant on behalf of business operating business with overseas connections. So obviously, if a business wanted to come to Australia, expand whatever the project that it seeks out to, it will require to send somebody to be in Australia. And that somebody is not temporary or not in the short term, required to be there for at least, month, half year, a year, 2 or 3 or 4, in whatever the project it is, to expand further. So that is what it's trying to explain and assist to fulfill a contractual obligation of the applicant. Example of type of evidence are considered decision making include, but not limited to. So these are example: company of business expansion, joint venture agreement between standard business sponsorship applicant and the party in Australia, and a contract between the standard business sponsorship applicant and the party in Australia. So it's the same. So it can either be going to be contract between overseas and Australian entity, or a joint venture agreement. Joint venture usually will have rely on mostly states or government related project. For example, minings. Okay, minings are generally in a joint venture partnerships. So it will be a very complicated contractual agreement, not just a very simple contract between two businesses. So it's a little bit different. In each case, because of supporting documents, by its nature usually considered sensitive and commercial in confidence, decision maker may request but shall not insist the applicant to provide full copy. So obviously it's trying to say that the government is not interested in the trade secrecies, but at least you need to provide some sort of document with some confidential information blanked out or cut out, but actually provide something to show that there's a genuine intention of business expansion there. It is sufficient if the applicant provides exact relevant parts of business expansion plan, contract, joint venture agreement, or exact content contains sufficient information. So that's exactly what I just explained. Company business expansion plan. In consideration of plan, decision making should have regard level of detail contained within that is a plan, should not simply be a brief or vague declaration. So it should be some sort of comprehensive business plan rather than a 2-page brief. So that would be too brief, because it's literally getting somebody on board in Australia to expand business. So the government will expect that somebody or the business or the entity will have a comprehensive marketing plan, or else why would you want to come to Australia to expand your business? So there will be a genuine realistic commitment and proposed activity, establish branch office, incorporate subsidiary company. The plan might, for example, identify location of business operation in base where it's going to base, and propose size of business, number of staff to be employed, capital funds, and set aside establishing business operation if the business operating involve incorporating a new subsidiary company, type of trading activity, blah blah blah. So that's the detail there. Joint venture, as I have explained it right above, the agreement shall clearly identify applicant party proposed joint venture, provide information on such purpose of joint venture. So usually will be with the state government. That's what what I have seen in my previous case studies. Contract between the SBS applicant and the party in Australia. Contract should clearly identify applicant as a party of contract, and the term of contract should indicate matters such as duty or applicants required to perform in Australia fulfill the contractual obligation. So basically, that talks about any overseas business wanting to expand into Australia, whether by itself to set up subsidiary, for example, and with a business plan, or in a JV, joint venture, or perhaps in the contract with another Australian entity and looking towards further expansion of whatever the commercial value or industrial value that the business is looking towards to achieve towards. Now, that is great because through these overseas business expansion into Australia, there's a potentially availability to actually nominate an overseas worker. Now, talking about overseas worker, there is very good exemptions in regards where I wanted to talk about it's the English proficiency. Well, despite I will still really strongly recommend that you have a good English, at least 6, to actually get into the visa. But if we're looking into this subclass 482, which is the visa category for all the employment sponsor visa, if you look at the exemptions parts, you may hold these passports, so Canada, New Zealand, Ireland, UK, or USA, then you will be exempt, or you have been studying whatever the courses in those countries with English, or you are a diplomatic staff. Or let's look at this one. If an employee of an overseas business, which is the one that we just talked about, and the business or its associate entity has nominated you to work in Australia, now, whichever the nominated occupation, as long as you will receive a guaranteed annual earnings. So that's going to be in the employment contract with at least Australian dollars $96,400. That's only about $26,400 more than the Tismet, that's the 70,000. Then you will be exempt from having to provide English. Well, which is great for a lot of Asian countries' employees. Now, you may ask, you may question, then, but that's just the work visa. However, you get a 4-year work visa. What do you get out of that is what we wanted to talk about. It's also in the policy as well. It talks about the 96,400 that's going to be exempt. And the beauty of this is that whilst you hold a TSS visa as an overseas a skilled migrant under overseas business to come into Australia to expand, well, that's what you need to do. The good thing is all the 482 visa holders will actually access to what we call the fee exemptions. What is that? Now, fee exemptions is open for, I think, most of the state and territory in Australia. So I'm demonstrating here with the Queensland state government. Now, what is this? This is actually for the 482 visa holders' children to access to state school with fee exemption. That means you are not required to pay international student fee for your kids. Okay, but that's only for state school, not the private and not the university or TAFE courses. Okay, so, and this will cover, as you can read this one, it will say this policy is specifically focused on providing for charges fee of education to school who is not an Australian citizen or permanent resident or child of an Australian citizen or permanent resident, and there is exemption. So if you read down here with category exemptions, they basically talk about if you're a New Zealand citizen, or you're a party of your research fellow, or party of the Australian agency or something like that. And there is a number 6. It says visa category other than the student visa. So once I click on this one, it will jump straight to this. And if we scroll down to the visa category 482 here, if you can see that there, well, it's tiny, but my cursor will go through here And I just, can I highlight that? Yeah, I can well, not quite. Okay, here we go. Okay, so that's 482 visa. So if you work as a skilled migrant employed by overseas business expanding into Australia holding that visa, and provided with the English exemption there, your children as a holder of 482 visa dependents will actually access to fee exemption here. So what does that mean? It's actually very important because a lot of international travelers or business, associates coming to a country will actually seek for, family to come as well. So if the family can establish in the areas where the kids going to school, that's very important. Then obviously that will help out the family to settle much better. So that basically meant that the 482 visa holders' children could access to free, or fee exemption basically means free tuition fees for school age kids. So that's from year 1 up to year 12. Now, last but not least, obviously a lot of people will ask, now if an overseas business could actually continue to nominate the visa applicant to become a Australian permanent residency. Unfortunately, the answer is no. So if we go into the, let's go into the subclass 186 TRT, temporary residence transition stream, we'll have the answer right here. Now, if we go into the eligibility, it will have toggle to the sponsor side. So if you go into the eligible business, if we click on that, it will basically tells you that the business has to be lawfully operating in Australia. So it's gonna be an Australian business in order to actually meet that requirement. It cannot be an overseas business for this pathway here. And if we go back to the applicant part, it will have the similar information here to nominate by an employer, sponsored by a work. So here we go. It says sponsor you for the 2 or 3 years, but it cannot be eligible business, means you must be nominated. Here we go. Clear sentence here. You must be nominated by an Australian employer. Okay, not an overseas employer. So unfortunately, if you wanted to become a permanent resident, then during your expansion, you probably already set up another new Australian entity, and you need to transfer your 482 visa to that new Australian entity and trade it under that Australian entity in order to meet the pathway to PR. And also the other side I want to talk about, for 186, in order to transfer into 186 permanent residency, there is no exemptions on English. You are required to have competent English. If you don't have a competent English, you cannot lodge to become a permanent resident. And here it says from 16th of November 2019, there's no more exemption on English language requirement. So there's no more exemption anymore. So if you want to become a permanent resident through employment sponsorship, get IELTS 6 across 4 band, and that's 100% you need to do. Now, age, a lot of people may ask that too. Now, if I'm 45, what I'm gonna do? Okay, there is an exemption here whereby as a subclass 457 482 visa holder, you have been working nominated occupation, nominated employer at least 2 to 3 years during a 3 year ending immediately before you apply. Your earning of each year period whereby at least much as Fair Work high income threshold. Now, what is that number for the Fair Work high income threshold? That's currently sitting at $167,500. That's about 70,000 more than the English exemption on the $96,400. So you need to be paid that much in order to exempt on your age, but there is no exemptions on the English part. And that is for today's video. If you're really looking to potentially utilizing overseas business expansion to Australia and get your visa. Now, why am I talking on this topic? Because there has been so many people questioning whether there can be a self-sponsorship. Now, it is generally banned on self-sponsorship for employment sponsor visa under Australian policy and regulations. But there's only one way to do it. You have to come from overseas, and that is the only way to get it done. Anyway, should you have more question or query, more than welcome to leave comment right down below, and I'll see you next video. Goodbye.